Good morning, everyone. Today we're going to have a resentencing hearing that is not unexpected. As you're well aware, there were two paths to get to this resentencing hearing. One was the court's own motion, and at no point did we oppose that motion. In fact, we said we were prepared to go forward with that motion. The second path was the prior district attorney's motion for a resentencing hearing. We sought to withdraw that motion because that motion left out a huge amount of key facts for the court to consider into whether or not the Menendez brothers have been rehabilitated and whether or not they continue to constitute an unreasonable risk of danger to society. Those facts and all facts are not facts that we fear. We want all facts to come out at this hearing, good, bad, or indifferent, facts or facts. The other side chooses to start the factual picture not back in 1989 when these brutal murders occurred, but when they started to serve their prison sentences in 1996. While those facts over the last 30 years are very important, so too are the original facts of the brutal murder and what happened at that time. Because we believe, and the California courts confirm, that in order for someone to be rehabilitated, they need to fully come clean with all the entire breadth of their criminal conduct. In this case, the Menendez brothers for the past 30 years have not come clean with that information. For instance, they have perpetrated the lie, a lie of self-defense. And it wasn't their original story, it was actually their fourth story on why they brutally killed their parents. And as we shown in an 87-page filing with the court, the Menendez brothers concocted this self-defense defense because they had a pre-planned alibi hours before where they were going to supposedly be at Batman the movie when these killings occurred. They had bought the shotguns that they ended up using against their parents 2 days before in San Diego using a fake ID and a fake address in order to make sure the shotguns could not be traced back to themselves. When they committed the murders themselves, they staged it to look like a brutal mafia killing, shooting their father through the back of the head, their mother who lied dying and bleeding on the ground. They reloaded the shotgun, put it up to her cheek and pulled the trigger. And then after the parents were dead, they shot them each in the kneecaps in order to stage this as a mafia killing. They then, as you recall, originally said, we didn't do it. That there is someone else who did it. Originally, they said the mafia actually killed their parents. And had they not actually been caught and arrested and had tapes come forward where their confessions were identified, to this very day, I believe, they would have perpetrated that original lie that they weren't involved in the killings at all. But when they got caught, when it was on tape, they had to admit to it. But they didn't just admit to the killings, they then concocted this self-defense defense, that their parents were going to kill them. And when I say parents, I mean both Jose and Kitty Menendez were going to kill them the night of August 20th, 1989, so they had to shoot them first. Of course, that is a lie. And they went beyond that initial lie of self-defense. They perpetrated additional lies where they tried to get one of the brothers' girlfriends to say that the father was a violent rapist. She refused to say that. They did try to get another girlfriend to say that the mother had tried to poison the entire family. Lyle Menendez actually wrote a script that came out, and word for word, that is what this additional girlfriend testified in the first trial, but after the script came out, she actually didn't testify in the second trial. Yet each Menendez brothers testified to the same additional lie, that the mother tried to poison them. Now, the reason we focus on what happened back in the 1990s is not because it happened in the 90s, is that because it's happened over the last 30 years. In order to be truly rehabilitated, you have to acknowledge the full breadth of your criminal conduct, your cover-up, and your lies. So the Menendez brothers, instead of coming clean over the last 30 years, when they were not just in their 20s, but their 30s, their 40s, and now in their 50s, as recently as an interview they did on TV about a week and a half ago, they have had every opportunity to come clean and say, look, we did it. We lied about why we did it. And here are the lies that we have told, and we want the world to understand that we now understand all the breadth of our criminal conduct and are prepared to be rehabilitated, be resentenced, and returned to society. They have not done that. And when people say, does the prosecution oppose resentencing? The answer is not no. The answer is not yet. And the reason I say not yet is that we have identified a pathway for the Menendez brothers to come forward, acknowledge all the lies they have told for the past 30 years, and then at that point, if they do it unequivocally and sincerely, and they convince the court, because ultimately the court has to make the decision here, then they can then say to the court, we have come clean, we have been rehabilitated, we no longer constitute a risk of danger to society. But until that happens, the answer is not yet for resentencing. Now, we have actually filed, one of the issues that has come up recently is that we filed a motion dealing with a report that we received from the parole board 2 days ago on April 15th. We have not worked, the district attorney's office has not worked with the parole board, we have not been in contact with the parole board, yet we received a comprehensive risk assessment from the parole board in connection with the parole board's activities for the June 13th hearing they're going to have. When we received that risk assessment, we believed it constituted additional facts that the court should consider in deciding whether or not the Menendez brothers do pose a risk of danger to society. These additional facts are based on a review that the parole board does that is comprehensive. They look at all the records, the prison records, the interview records, the reports in the prison. They talk to various people throughout the prison system about the Menendez brothers, and then they prepared a report that analyzes their view of the comprehensive risk that the Menendez pose of potentially being a danger to society. So we wanted to make sure that the judge got a copy of that report and considered it in connection with this sentencing. And by the way, that report, as it pertains to the parole situation, is just one piece of the information that the parole board will consider on June 13th when it conducts its own hearing. But again, it represents additional facts. And the prosecution doesn't fear facts. We want every single fact, good, bad, or otherwise, to be before this resentencing judge so that he makes the right decision. So we basically said, the judge, if you want additional time in order to get this report and to consider it, we, the prosecution, are willing to agree to any additional time you want. And by the way, if you don't need any additional time, and you can get this report through a request to the governor's office, and you can consider it in connection with the resentencing hearing, we are ready to proceed. So what you'll see today is we are proceeding on this resentencing hearing. We believe that the defense will call a number of witnesses as part of the proceeding. We will then at some point have argument. We hope that the court will then get this comprehensive risk assessment point at some point. And then we don't know what the court's ultimately going to do. Will the court rule from the bench at the conclusion of the hearings, probably tomorrow? The court could do that. Could the court take it under submission and decide it wants to provide its thoughts and its opinion in written form and issue an opinion? That too is an option. Could the court have an additional hearing at some point where the court wants to hear additional argument on the various factors and either rule from the bench or rule in writing? That too is an option. So I don't know exactly how the court would like to proceed, but the prosecution is ready to proceed today. We've always been believing that this resentencing hearing would occur. It is going to occur. And again, we don't oppose, our answer to resentencing is not no, it's not yet.